Good afternoon. My name is Eric Cherry, MP Weislaw, and we're here today to talk about businesses in divorces. You might not be surprised to learn that businesses happen a lot in divorces. One or the other spouse, sometimes both spouses, will have a business interest of some kind, whether it is their primary source of income just for themselves, or whether they have employees and a little bit more of a structured environment, or whether it's a full-fledged corporation. And you should know right off the bat that there are two main kinds of businesses that people tend to have, and those are limited liability corporations or closely held assets, where you have either one owner or maybe three or four owners at most, and that's more or less it. This is not an organization that sells stocks. This is just a closely held, few people business interest. That is the most common thing that you'll see in divorces. Every once in a while, though, you'll have somebody with a much larger organization that actually is a corporation with many employees, dozens, sometimes hundreds of employees. In that case, it's a different situation. But let's start with the most common situation is where you have the closely held business assets. Rule number one, have an operating agreement. You should have an operating agreement for your corporation or for your limited liability corporation, because if you don't have ownership stakes clearly defined for the business, amongst various other things. And you want those clearly defined when you get into a divorce stake, especially if there are other owners beyond you. If you don't do that work, you run the risk of what the court is going to decide is the ownership situation. You might not be surprised to learn that an ownership stake in a business is an asset that can be divided in marriages or in divorces. And as a result, you're going to be paying out if you want to keep your business to yourself, to your spouse, for whatever that business is valuated at. And that brings us to the next topic, how to value that business. There are two dates that you should have a clear valuation for your business on: the date of marriage and the date of divorce, or at least the date of filing of your divorce complaint. Now, most people don't do the first one, and that is important when you have had that business prior to getting married, because the only portion of your business asset that is dividable in a divorce is the marital portion, the portion that occurred during the marriage, so the increase in value over that time. And it doesn't matter that she didn't work at the business. It doesn't matter that you were the only one who put in any effort into creating the business. That is a business asset, and it becomes a marital asset because it occurred during the marriage and was contributed to by you. As a general rule, the only time an investment of any kind is separate on the date of marriage, as in you put all your money and effort in prior to marriage, and that is a thing that existed before you got married, and it remains separate all the way up until marriage, is a passive investment, meaning you cannot be involved at all. You have to be literally sitting on the side, looking at your investment increasing in value. If you're doing anything beyond that, it's a marital asset, at least during the course of the marriage. So if you are a business owner and you are considering getting married, you should value that business. You should hire a business valuation expert to value your business and create a record of that around the time of your marriage. Even better, do a prenuptial agreement, because when you're doing a prenuptial agreement, you will do that business valuation as part of creating prenuptial agreements. But even if you can't, for a variety of reasons, at least value your business on the date of marriage. When you get into your divorce, you're also going to hire maybe that same company, maybe another company, to do a business valuation at the date of divorce. And then the difference in value between those two dates is the marital asset that is subject to division in a division of property agreement or order of the court. So keep that in mind, because that's very important as you are, considering a divorce, is how to divide property, and if you're going to retain your business, how much money you're going to need to come up with to buy your spouse out of their marital interest in that business. I'm going to go to the ownership by other people piece for a minute. Here's where having an operating agreement comes into play as significantly important. If you do have other people who have contributed to the business, whether by labor or financially, and as a result of that, you have given them an ownership stake in your business, and you don't document it, you're running the risk that the court is going to consider the entire business a marital asset, despite contributions of your family, friends, or whoever else is owning this business with you. You have to have clear records on how much somebody has contributed, whether it's financial or through labor, and what amount of ownership that bought them for doing that labor or contributing that money. And if you don't have that, you're taking a chance. So it's very important you create good business records for the division of ownership stakes in your business when it comes time to have a divorce. When you have a complex series of investments and assets and a divorce, this actually gives you more options in a way as to how to settle cases, because you're going to have a harder time dividing a business, especially if it is a solely owned business or a closely held business where you can't get into having the spouse, the soon to be ex spouse, having an ownership stake in that business. That's likely going to fundamentally change the decision making structure of a business that will result perhaps in the decline of a business or the poor performance of a business. And you don't want that to be a possibility. So if you have other assets that you can use to either liquidate them or to trade them to the spouse in exchange for keeping the business asset, that gives you more options. But oftentimes our clients will have, several pieces of real estate where the same logic applies as far as valuation on the date of marriage, valuation on the date of separation or date of divorce. Those are important numbers to have. Investments are a little bit different. I mean, in the way that they are the same, you still have the separate property interest, kind of meets the same logic that we've been talking about. But if you have, investment that's more or less cash, sometimes it's pre-tax cash. And if you were to, like, oftentimes it's pre-tax cash that you are not able to take out. And if you did, you take a tax hit. But in a divorce, you can do a QDRO, a qualified domestic relations order, which allows you to divide an investment property and transfer it to the spouse without making it available in a liquid form, therefore avoiding the tax hit. So if you have a lot of investments or enough investments that you could perhaps give her an entire account, him or her, instead of the business interests, that might be a way to keep the business in your name and not worry about providing the other spouse their portion of the business, because you can take care of it another way. And that would apply to any other asset that you might have, collections or cash savings or what have you. Whatever you have available to you, technically this would be divided, but if you could give her the entire thing as a compensation, that gives you options. Most businesses that are closely held in particular, they are going to be the owner's primary source of income. And so for purposes of other calculations like child support or spousal support, whatever your income is from that company is going to be the number that is used. And you have to be careful because a lot of times, let's say certain kinds of businesses will do their best to account in such a way that the business will show no profit year to year, and they are paying themselves. If you do good records of paying yourselves and you create a W-2 for yourself and whatnot, that is great. Then you will actually have clean records of it. If you don't, and if you kind of take benefits from the business over the course of time, or maybe take cash out of the business and call it something else, people do this. You're taking a risk. You're taking a risk that the court will end up deciding what your income is. And if your spouse has a particularly aggressive style about them, they might try to evaluate your lifestyle as indicative of what your income is. So if you're driving a Tesla and you're living in a $750,000 house and you are taking trips every few months to overseas and whatnot, even if you show on your records, I'm only making $50,000 a year, Your Honor, that's not really going to, meet muster. The court's going to think you're lying, and then they're going to make up their own number. So better to keep really good income records for yourself. Now, with spousal support specifically, you will oftentimes a consideration for spousal support is what other benefits are available to a person after the divorce is granted. So this goes right to investments, to the business assets. Let's say we've divided and we've given her, in this scenario, the wife's spouse is not working in the business, the husband is, but we have divided to her an investment property worth $250,000, let's say. Okay. And the business itself, after the business valuation was done, was $250,000. So that was a fair trade. Okay. Now the business is going to be producing income for the husband in this scenario. And considering the wife doesn't have income necessarily from that, but eventually will have a drawable asset when she retires. Right. The court is going to take into consideration that wife now has this $250,000 asset that she can have for retirement purposes, that is going to balance against her getting a large spousal support payment, at least reduce that number a little bit. So that's another thing to keep in mind when you're doing your settlement options. If you have business interests and you are looking at divorce, you should talk to an attorney well ahead of filing a divorce case or well ahead of expecting a divorce to be filed so that you could do some preparation as to what your business valuation is and what other assets exist so you can plan for trying to divide property in a way that doesn't disrupt your daily income and disrupt your business in a fundamental way. Eric Cherry, MP Weiss.